Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
If John was beaten up and attacked in that house, who did it?
We don't know.
We don't know.
We don't know. And it's not for us to know. Somebody other than Karen is responsible for that, for the killing of John.
Roberta in the truth zone, mic hitting raw. Spotlight shining, she exposing the flaw. Debunking the myth, breaking their facade. This is Glass City, respect the squad. On these NYC blocks where the skyline flex big. Roberta Glass slicing lies with a truth rig. Innocence frosters, your stories unravel. She's a map through the madness of gritty gravel. Glass don't bend and facts don't break. She's a storm that's called, you feel the quake. Exposing tales stitched with crooked seams. Justice in the lens, shattered fake dreams. Screams about killers, painted heroes in disguise. She burning propaganda with fire in her eyes. No glamour for the guilty, she call it straight. She backs victims, the voice stay away. Stats and receipts, no spin, no clutter. Cold cases whisper, she cuts through the mutter. Truth's her tempo, don't confuse the beat. She's standing for the real while you taking a seat. True crime's a block, facts the artillery. Spinning those lies, yo, she checks that misery. Tabloid tales get smashed, no time to play. She's glass hard, break the false and save the day. True crime's a block, facts the artillery. Spinning those lies, yo, she checks that misery. Tabloid tales get smashed, no time.
Okay. I feel like I've never left. I'm back, and I feel like I've never left. Well, it was an exciting day in the Karen Reed trial. Well, it ended on a bang, certainly. Hey, Jude. It's not that long. The intro's not that long. You'll make it through it. Hello, Mark Carr. Hello, Jennifer Ray. Hello, Carmel. Rockstar, JMS, Barb Nauman, Iowa. Hello, everyone. Please hit the thumbs up on your way in. Let's get this algorithm moving. So it was Squirty Bello on the witness stand for the Commonwealth talking about John O'Keefe's cause of death, and the defense put up such graphic pictures of John O'Keefe's stomach that a juror had to call for a break. Really disgusted. The jurors, I noticed that looked like, to my eye, correct me if I'm wrong, but it looked like Mrs. O'Keefe and the really close members of the O'Keefe family exited. Yeah, Robert Alessi decided to talk about, basically essentially do his job, but in a very callous, probably didn't really read the room, too sensitive way. Yeah, I thought it may be a dumb move for the defense, but what the Free Karen readers are talking about is Squirty Bello said that the cause of death was hypothermia and blunt trauma to the head. And the Free Karen readers are all saying that just couldn't be done by a car. And the fact that she couldn't, which really isn't her job, suss out the mechanics of how it happened. It's not her job. That how is the Commonwealth going to overcome that? I don't know. My question is, how is the Commonwealth going to overcome this judge? They've been dealt such a drastically unfair hand with a judge whose sole concern is on Karen Reed. Not that just, if it were just that she get a fair trial. Now, that's, of course, what she says is Karen Reed's right to a fair trial is paramount, which it is. But it's not, Karen Reed's rights are not ever balanced out with the people's rights, the victim's rights, or the state's rights. So the defense can act any way that they like, violate continually Rule 14 violations, talk to their experts on encrypted apps, have their experts lie to the jury first time round, lie to the judge, with just a talking to, no more lying, and then the lying starts up again. So I don't know. I don't know anymore. It will be a minor miracle if Karen Reed gets convicted of anything in this case. Not because I don't think, and I was just saying, closing today, that this might be one of the most open and shut cases that I cover. And they're also obviously guilty. I mean, get 12 people to agree on anything. So usually what I'm talking about when I'm talking about cases on my channel, if it's not cases that I'm reporting on from the courtroom, I'm usually talking about the wrongful conviction movement overturning convictions that were done 14, 12, 14, 20, 18 years after the killer was convicted. And they're just trying to overturn them and say that they're iffy cases or with a documentary or some kind of advocacy. But this is just such an obvious case of a hit and run. I mean, there's just, the conspiracy theory does not hang together in any cohesive way that incorporates all of the evidence. So you can say, well, the marks on John O'Keefe's arm kind of look like dog bites if the dog had no lower jaw, maybe. Maybe. But then you have no dog DNA. Then you have no evidence that he was ever moved. He ever moved from his spot for the cell phone. Then you have all her taillight pieces with John O'Keefe's DNA scattered in the same area. He was literally lifted out of his shoe. And the glass he was holding, that was found in that area. Pieces of the cocktail, Karen Reed's cocktail glass he was holding. I mean, why would they take him out with the cocktail glass he was holding? Why not just dispose of it somewhere else? I mean, it just doesn't even make any sense. And then never mind also that the car was on its way to the Sally Port when the CERT team was on the scene finding pieces. So there's no time to plant the evidence. So besides all that, it's a great theory, you know. And so let's start off talking about Robert Alessi and his really, I would say, what do you call it? Insensitive move. But before I do that, I want to talk about something. Now, Innocence Fraud Watch is just been kind of amazing on this case. A lot of really on top of things that, and this is something that someone said in the comments that maybe I missed. I've been trying to figure out what this garage door, the point of Adam Lally constantly referring to this open garage door, the first trial. And I believe that it's not just the insensitivity that Karen Reed left it open, but could Karen Reed have, and someone guessed it in the comments, changed the code? And I want to just briefly shuffle through Innocence Fraud Watch's excellent blog on the subject. So, whoop, is this it? Here we go. Killer Karen Reed, retrial. What did Margaret, Peggy, John Jr., Papa, and Paul O'Keefe uncover regarding the garage door at Meadows Avenue on the morning of the 29th. So Karen Reed left John O'Keefe's right-hand side garage door open before showing witness Jennifer McCabe and Carrie Roberts her smashed to smithereens taillight. So she has this garage door pad, and people just made up things that she had some kind of remote control opening to the garage door. No, you can see his keypad on the door. And there was this, and Karen Reed had stated there was a few small pieces of taillight missing that I had picked out of John O'Keefe's. I had picked out at John's at 5:45 before we drove to Fairview. I'm showing Jen and Carrie, look what I just did to my light. And I'm worried that there's gonna be some kind of electric short circuit. There's like the bulb is showing and some of the red plastic is missing. So I picked out pieces of the light housing that kind of collapsed within the light and dropped them in John's driveway. And here's a still image from John O'Keefe's ring camera footage from around 7:05:16, showing Michael Camerano's car in John Meadows Avenue driveway. When John O'Keefe's friend Michael Camerano arrived at Meadows Avenue to collect John's niece at around 7:05:16, Michael found the right-hand side garage door open, which had been left open by Karen Reed. What a great thing to do, sensitive thing to do to a scared child who's lost her mother, her father, and now her uncle been murdered. And just leave her to go carry on and pretend to be looking for John O'Keefe where you know right where you left him, Karen Reed, when you ran him over with your large SUV going approximately 24 miles an hour in reverse, your foot approximately 75% down on the gas pedal, moving your wheel, turning your wheel into him, and never once touching the brake when your infotainment system, which is like a sensor system that would make that, I played that very loud whining noise that it would make at you. It would beep and flash, and it makes this whining noise. When I pulled in, Michael Camerano testified, and let's just hear his testimony, and I won't read it. So he testified that when he pulled in, the garage door was wide open to pick up Kaylee.
Camerano, you call your wife, and what, if anything, is it in general that she tells?
She tells me that John didn't come home last night.
And she's still at work at this point, is that correct?
Correct.
Did she indicate to you how she came to find that out?
She just, she said she's received phone calls from
whom?
Karen.
From Karen. And then based on that, you have a conversation with your wife about John's niece and nephew, is that right?
Yes, my wife says to me, go get Kaylee. Kaylee is home.
So at that time, your wife tells you that Kaylee is home in Meadows Ave by herself.
Yes.
And so based on that information, what is it that you do?
I realize that Kaylee's home alone, so I throw some clothes on, go out to the car, clean the car off real quick, and get in the car and go.
When you say clean the car off real quick, what, if anything, did you have to clean off?
I cleaned the snow off the front windshield.
And again, you sort of drive over to John's house to get Kaylee.
Correct.
And when you get there, you pull in the driveway as well.
Yes.
And when you get to John's house and you pull in the driveway, what, if anything, did you observe about sort of the condition of the garage doors at that point?
When I pulled in, I could tell the garage door was open, left open.
Which one? The one to the right? Or
To the one to the right.
And you go inside that door?
I do.
And what, if anything, did you do once you went inside?
Once I went inside, I saw Kaylee. I asked Kaylee get whatever she needed and to come and get in the car. While she was doing that, I started clearing some snow. I thought maybe snow hit the sensors so that the door couldn't go down.
And so you start clearing the snow with a shovel.
With the shovel that was in the garage, yes.
And after you had cleared some of the snow with the shovel, what did you do with regard to the doors at that point?
So I tried to put them down. They wouldn't go down. Then I asked Kaylee, I think, to re-enter the code to see if she could get the doors to go down, but the doors would not go down. The door.
And at some point, how did you get the?
So I manually, there's a red rope. I manually pulled that, shut the door, locked the doors. There's 2 side locks on the garage door, and I went out through the side garage door.
So he couldn't pull down the door. You heard him. It's almost as if Karen Reed changed the code to the garage door. When John O'Keefe's mother, Peggy, got out of her son Paul O'Keefe's car, she walked straight to the outdoor coded garage keypad, which was located to the left of the right-hand side of the garage door. Paul O'Keefe then caught up with his mother and captured standing looking on it. And there was continued issues with this coded keypad for the garage door. So Margaret O'Keefe appeared to have a problem with the coded keypad, almost like someone had changed the code. And the Ring camera footage shows Paul O'Keefe attempting to have a go after her. So he's attempting again to put in the code, and it's not working. Carrie Roberts can then be heard shouting something, and then they all appear to walk away to gain entry to the house elsewhere. Watch it, and we can watch the footage of it here.
161. And if you could just pause that just for a moment. Now, Mr. O'Keefe, what's up on the screen there? Do you generally recognize what's depicted there?
It looks like Karen Reed's vehicle, my brother's vehicle, and it looks like another SUV behind it. I don't know the 2 people.
If you could, just using the laser pointer before you, if you could just direct the jury's attention to which vehicle you're talking about when you. So starting with Miss Reed's vehicle, where is it in this video that you're?
I believe it's that one right there.
And your brother's vehicle?
Is back there.
And the vehicle you're referring to is your vehicle? Where is it? And if you know, when about is this video depicting in relation to what you've described as the events of January 29th?
I mean, that would be in the morning coming back from the hospital, mid-morning.
And as far as the people within this video, do you recognize any of the people within?
That'd be myself. I believe that behind me could be Carrie Roberts, because I believe that's Carrie Roberts's car. She drove my father back from the hospital to One Meadows.
And Ms. Gilman, if you could just run the video.
Oh, that's my mother.
So there she is, like trying to put in the keypad code in the pouring snow, which is what you want to do after your son's been murdered. And it's not working. Garage isn't working. Yeah, so come in the side door, right? Were the Keiths too traumatized to notice the garage door situation? And why didn't prosecutor Hank Brennan inquire about this when Peggy O'Keefe testified on April 23rd, 2025? At around 12:06, Karen Reed was caught on John O'Keefe's Ring camera climbing out from the right-hand side back passenger door of her brother Nathan's car. She was bizarrely wearing a COVID mask. The first thing Karen Reed did was make a hasty beeline straight to the coded garage keypad. where she then spent 6 or 7 seconds fiddling with it. As Karen Reed then moves towards her SUV to open the driver's side door, the sound of the garage door opening was captured by the Ring camera audio. The sound was not evident in the Ring camera footage of the O'Keefe's earlier arrival. Did any of the O'Keefes hear the garage door opening? Had Karen Reed reset the code? Was this the reason she made this move her priority when she got out of her brother's car, as opposed to rushing into the house to see the kids? Watch back to the video clips of Margaret O'Keefe from 10:36, and the cunning calculated Karen Reed from around 12:06 below. So.
Okay, thank you.
Odd, right? Odd. So someone else thought maybe that she was trying to, should he gain consciousness, that she would have locked him out of his own house. Or I don't know. What would be the reason? She could always use the side door. Was it to hide her car? That would, right? If you pull into the garage, to hide her car behind the garage. Or I don't know. So the police can't see it. Nobody can get in and look at it. That seems like it, right? That would be the reason. I don't know. What do you guys think? Did she change the code to piss off John, or to cover her car so she didn't want people in that area to see her car, right? Not have any access to it. So the police couldn't, she would have had to open it for the police, hide the car. Yeah, that's what I think. Anyway, I thought that was an excellent blog. Innocence Fraud Watch. Much, I'm always flattered when people say that. I am flattered and a little bit annoyed, because it takes away from all the great work she does, but that we're the same person, that I would lie to my audience and have a secret life. But she's been doing excellent work and is a lot smarter on this case, I think. A lot more on the ball than I am. I knew it was important. I just could not get what he was talking about with this garage door. Adam Lally. I was like, just spoon feed it to me, Adam Lally. Spoon feed it to me. Just tell me what you think. Pat Brooks. Hi, Roberta. Awesome channel. Awesome mods. Awesome community. I agree. Thank you so much, mods. Maestro. Latex Spouse. No, I'm Taterbug. Thank you so much. I have some people to thank. Speaking of awesome community, thank you, Pat Brooks. I want to thank supporting the channel on Venmo, Tara Shea, Marie Horton, Barb Nauman, Jen Buell, and on Buy Me a Coffee, Carmel O'Reilly, Mary Byrne, Lisa Larson, Tammy, and Gizmo. Thank you so much. I really appreciate it. If you want to support the channel, really, this is pretty much all listener supported right now, this channel. The links are in the description of this episode. Venmo, Buy Me a Coffee, Patreon, all fantastic ways to support the channel. Links in the description. Please hit the thumbs up. While we're thinking about it, let's go back to Alessi. Robert Alessi today, turning everyone's stomach, and then they shout ambush at the end. That that it's actually the Commonwealth who violated Rule 14, not the defense over and over and over again, that the defense only violated it. They're counting all their times as one time. Okay. Not a pattern and practice of hiding evidence from the Commonwealth in order to ambush them, but okay. So here is Alessi talking, sharing this really disturbing pieces of evidence that turn on the contents of, on John O'Keefe's stomach and its contents with the jury. Take a listen. They were warned, but apparently the warning was not sufficient enough. Take a listen.
And I'd like to move into evidence.
All right. All I'll say about this, jurors, is that this may be considered graphic. You satisfied with that, Mr. Alessi?
I'm satisfied with that, Your Honor.
Okay, Mr. Brennan, you satisfied with that?
Yes, Your Honor.
Okay.
May I, Your Honor?
Yes.
Dr. Schoeneman-Dilley, I'm handing you Exhibit 164 in evidence, and I'm going to also, with the court's permission, have it published on the screen. So whatever one is best for you to look at the screen, please feel free to look at either one. Mr. Wolk, if you could publish 164. Dr. Schoeneman-Dilley, do you recognize 164 as well, you described what 164 is.
This is a picture of the stomach of Mr. O'Keefe after it was removed and opened and the contents were removed. And what you're looking at, this pink red surface, is the mucosa. That's the lining of the stomach. And you had used the word rugae before. These are the folds. The stomach has a lot of folds. And what you can see here are small areas that are redder than everything else. That's hemorrhage, that's blood. And these are the gastric hemorrhages that I described.
Right, so those are what you just showed. There's darker areas, there's just a few of them. That is what you refer to as hemorrhages, correct?
Wisniewski's was correct.
Well, you didn't use Wisniewski's in your report, correct? You referred to them as hemorrhages.
Correct.
Okay. So what I'd like to do now is to, if I may approach, Your Honor.
Exhibit MM.
Your Honor, with your Honor's permission, may I show Dr. Schoeneman-Dilley the chalk that's marked for identification?
Yes, and let's see what she answers before we use it for more questions, okay?
Yes. May I hand it?
Yes.
Dr. Schoeneman-Dilley, could you please take what's identified as Exhibit M and see if you can identify what that depicts?
Yes, this is a picture of a stomach. Again, the mucosa with hemorrhage.
Just hold for these, not your fault.
Your Honor, can we take a break?
Yes. Yes.
Yeah. Do you hear that? You guys hear that? Can we take a break? One of the jurors. And then we have a very long break. And he starts using some kind of general not John O'Keefe's autopsy pictures into evidence, sort of like more general pictures of people's stomachs.
Dr. Scorti-Bello, is that the depiction that you were just describing at your witness stand?
Yes.
And could you please, with the laser pointer, state what you see in this depiction?
So this is a stomach. This is the mucosa, the folds of the stomach. They're not very folded in this particular picture, but you can see these distinct areas that are that have a darker coloration. That's blood. These are hemorrhages.
And to be clear, this is not the stomach of Mr. O'Keefe. This is a medical reference depiction to sort of generic or some other depiction other than Mr. O'Keefe's stomach, correct?
Correct.
If we could, with your honor's permission, Mr. Wolk, put side by side this chalk with what is in evidence as the actual gastric mucosa of Mr. O'Keefe.
The objection sustained.
Could we, with your honor's permission, publish simply Mr. O'Keefe's
Yes.
gastric mucosa?
Yes.
Isn't it correct, Dr. Scorti-Bello, that there are much less dark spots in this depiction of the gastric mucosa than there were in the chalk that we just displayed? In other words, that green depiction of what I'll just refer to as a generic stomach. Is that correct?
That is correct.
So you can take that down, Mr. Wolf. Isn't it correct that for hypothermia and the presence of Wisniewski's ulcers or spots, that you have to have a predominance of the stomach covered by the spots for them to be Wisniewski ulcers?
I think there's different levels and different grades.
In hypothermia, particularly death from hypothermia, wouldn't you expect to see a predominance of those ulcers, meaning they take up most of the stomach lining? Isn't that what you would expect to see?
Not always. I have seen that. I have also seen cases with much fewer spots, as you refer to them.
But isn't the majority?
So he's trying to say that he could get these kind of injuries he got from hypothermia. He goes on later to say, I'll spare everyone because I'm starting to glaze over myself. But from hypothermia. I mean, from hypothermia from drinking. He didn't get it from hypothermia, he got it from drinking. That's what the defense is trying to argue in this. Golden Grays, thanks for becoming a member. Unreal. So, and it goes on. So, but the real kicker of the day was at the end of the day when Robert Alessi starts talking about how something also Innocence Fraud Watch has been writing about, which is this drift time difference between different clocks in the case. And it's something that Hank Brennan talks about in his first, in his opening statement, Sorry to lose my mind here. Hold on. So let me just, I'm not going to go through the whole thing, but just so you get the idea, I think it's an important concept to get a little bit before we go through the whole argument that he accuses the Commonwealth of hiding discovery Rule 14 violations. So Rule 14 always has to deal with, Rule 14 has to deal with this, has to deal with not handing over discovery, meaning that when the defense compiles evidence and when the Commonwealth compiles evidence, they share it so that no one is ambushed. Everyone is working, understands what the arguments are on both sides. The way that the defense has been fraudulent, I'll say, is by skirting having to hand over their communications with their defense experts, the way the Commonwealth has, by saying we've never talked to them because there's a federal investigation. They started that with the ARCA experts because they know they're the best experts they have. They're the hired guns for the defense that lied on the stand. Daniel Wolf lied and said he wasn't paid, never seen Alan Jackson before because he couldn't, because he was hired by the federal investigation. In my opinion, there's not much different between the federal investigation and the defense team. The federal investigation was started so that there would look like there was impropriety, so that Karen Reed, the Commonwealth, would fold and drop the charges against Karen Reed before it ever went to trial. That didn't work. And so on the stand, the ARCA expert, so this is this accident reconstructionist expert, testified that he never seen Alan Jackson before because he couldn't, because he was hired by a totally different entity, meaning the feds. And he wasn't paid or retained, and that the Commonwealth could have used him. That's how he testified under oath. When we found out that they were in communication, they were retained and paid $23,925. All that is straight up perjury. That said, it's not like the judge said, go find yourself another expert. I'm not going to have my jury lied to. No, she's like, no, bring them back. Let's have them lie to the jury some more. And then we found out in a voir dire, due to these discovery violations for the defense, that the same expert, Daniel Wolf, had erased over 100 text messages. He had no text message communications between himself and the defense team. And he was communicating via encrypted app, which is Karen Reed's favorite way, the Signal app, to communicate with Turtle Boy and the people orchestrating, helping her orchestrate her innocence fraud campaign, and like Aiden Turtle Boy Carney and Natalie Bernschneider-Wawicki, who was the intermediary between Karen Reed and Aiden Turtle Boy Carney, the blogger who has pushed this innocence fraud narrative for Karen Reed forward in the media, in his blog, on interviews, everywhere he can. He has now 18 witness harassment charges against him, all done to help Karen Reed evade justice from and evade responsibility for her murder of John O'Keefe. Killer Karen Reed retrial, the obvious deception, and this is of Mark Betterow, the Aiden Carney's, the blogger who I just talked about, his lawyer, one of his lawyers, Mark Betterow, on powerful and unmoving testimony of state witness Jennifer McCabe. So he's saying that Mark Betterow is saying that he manipulates narratives for his client's advantage for a living. So he falsely stated that 12/31/38, an incapacitating car accident occurs. This is not the Commonwealth time, and it suggests Karen Reed incapacitated. It's not the Commonwealth suggesting Karen Reed incapacitated John O'Keefe. The 30-second time variance. So there's a clock drift of a black box to John O'Keefe's phone. So there's a 30 seconds difference between the black box and John O'Keefe's phone. Special prosecutor Hank Brennan talked about this in his opening statement. And he said, you'll have some information from the defendant's Lexus black box. The clocks run differently. There's a 30-second variance, but it's right in the heart of the matter. So I won't continue on with that blog, just not confuse things, but I think that's an important concept to have when you hear Alessi starting to make his arguments in the beginning about how the Commonwealth and their expert has amended his opinion to deal with the clock variances between the black box. And so this is expert Shannon Burgess, who, hold on, go to the end of the day, who works for Aperture. So he's a digital forensic expert with extensive experience in investigating and reconstructing motor vehicle accidents, with a background in industrial control systems operations and research aid work. Shannon has a Bachelor of Science in Applied Mathematics and Scientific Computation. Shannon has worked in various positions relating to forensic analysis and accident reconstruction, demonstrating a strong technical skill set and expertise in analyzing digital forensic artifacts from mobile device, cloud, IoT, and vehicle systems. So there he is. And here is Robert Alessi making an argument. Look, here's still, we now have the Karen cam up for anyone who's been away from watching the trial with us. We now have, thanks to Maestro helping me out with being patient, eventually figured it out with the technical aspects of getting the Karen cam going. We now have a Karen cam, but look, there is Karen's father, William Reed, still next to, I think this guard is going to be there. It looks like every day now for the trial because of his own behavior. Now, I don't think we've really heard a full story about what happened there, what exactly he did. I don't think it's just staring down the jury. I think it's something much more explicit. But she stands up and protects the jury. So here the jury is dismissed. Hold on, let me take a look. And they start arguing. Hold on. Maybe I need to. Thank you for your patience. I thought I had this the right time. Okay, here we go. So Robert Alessi is saying, because he says that there's a time difference between this car data act that happens at 12/31/38 and 12/32 that's been amended to 12/32/16, that their whole case is different now. Thanks, Maestro. Am I not sharing? Am I not sharing the right tab? Thank you. It's been a long day.
Right up
Thanks.
until not established, they had stated in the reports of Aperture, particularly the slide presentation of Dr. Welcher, a trigger called 1162.2 that they had Dr. Welcher with a specific time. And that specific time that they have associated with that trigger is 12/31/38 to 12/31/43. And we have been assuming that information, and this is from best memory, but I believe it's slide 137 or so, where this statement is in the slide. And so we have proceeded with our defense. We have proceeded with the work that has been assigned to ARCA based upon that time period. On May 8th, not too long ago, Your Honor, we received an amended report of Shannon Burgess that pushes that time period. I'm just going to give. So, although it was dated May 8th, we received it actually on May 11th. And in that report, Mr. Burgess states that he is making an amendment, and he is now stating that that infotainment trigger of 1162.2 is further back in time, and it is past 12/31/43.
Do you have the time?
I'm going to get the exact time, Your Honor. It is 12/32/16. And Your Honor may recall that the seconds, literally seconds, matter in the analysis of many factors. I won't go into them other than to say I went through and developed testimony with regard to the cross-examination of Mr. Whiffen. He had a timeline. He talked about much human volitional conduct. Suffice it to say that that information is literally by seconds determinative in some ways of various analysis. So we basically commissioned, if you will, ARCA to be looking at matters based upon the infotainment trigger 1162.2 of 12/31/38 to 12/31/43. As of May 11th, we received information that has changed that. Now, Your Honor, that is a Rule 14 violation, among other issues, but I wanted to start there. It's a Rule 14 violation. It's obviously, as I stated, an amendment of a report of a significant matter. And also, with regard to the defense's ability to provide a defense, we have to be able to evaluate that information in terms of our entire defense. And it's just not limited to ARCA, it's our entire defense. The other data point I want to get to, so the effect it's had, we still haven't even been able to evaluate entirely that. And I believe, Your Honor, based upon the information that I have, that this may have been a calculated matter by the Commonwealth, but even assuming it's not calculated.
Right. He's saying, did you just hear what he said? I think it's calculated by the Commonwealth. The Commonwealth is really, it's not us who have done, okay, and I'm adding the before Alessi got there, okay? He's new to this trial. Marie Russell, McNasty Green, right? Richard Green, the digital forensic expert. They just Rule 14 violations. They had to have a voir dire on both of them because Marie Russell strangely volunteered herself through the through an LADA's office. John Lewin, friend of the show, tried to get the real scoop that ever happened. He's not saying a word, not even verifying it or not verifying it. I don't know, guys. Did Alan Jackson just throw in John Lewin into this? Did she contact the defense team directly? Because remember, Alan Jackson used to work at the DA's office in LA. Did she literally come in off the street? And did Alan Jackson bring up his old friend John Lewin into the mix to make it sound more, I don't know, or was John Lewin really in the mix? Hard to believe they lie so much. And then we had Richard Green, I guess, what was it? What was the problem with Richard Green? No report for Marie Russell, no information for the Commonwealth. Richard Green, I can't even remember what the problem was, but that was a discovery violation. They had to voir dire him. And then this time round, excuse me, my memory is failing me. Help me out if you remember what the issue with was Richard Green. Did he not write a report first time round? Yeah, AJ's wife works there now. Alan Jackson's wife works there now, Maestro. But Alan Jackson worked there for a minute and a half and then ran for a DA and lost. So Lacey won that. Yeah, can you remember what the issue was with Richard Green first time round? I'm forgetting. So this time round, we have ARCA. Again, we have the ARCA. They've done all these new tests and they haven't handed over anything to the discovery, haven't handed over any of their communications. And at the last minute, when they were about to get, they hand over a few emails that are hugely telling, where they're helping narrate and script the testimony of ARCA, these supposedly independent, non-biased witnesses that the Commonwealth could have used and who, as Hank Brennan says, and who knows no one. And I think that the day that they had to hand in those emails, along with their retainer and what they were paid, $23,925, sure they were paid more this time around. I think that's when they told them to get on the Signal app and erase all your communications because we don't want to hand them over. We're just going to say they all got erased. That's how I think it went. I think there's no end to the dirtiness of the defense team. But they're saying an amendment is hugely different. The amendment that was mentioned in the opening statement. Was no one listening on the defense? Amendment having to do with the time that was brought up in the opening statement? I don't know. Seems pretty small to what the defense has done in this case. But look at the timing of it. So this is right before the Commonwealth asked the judge, because the judge letting in these ARCA witnesses said, well, the Commonwealth said, look, our rebuttal witness is going on vacation. He's not going to have time to review any of these new tests that ARCA has undertaken. And the judge said, well, it's got to be handed in by the 7th. And then after that, I'll work with you. And what Hank Brennan is spoiler alert, going to propose is that after the defense team goes, he brings his witness as a rebuttal witness. I mean, I don't think this is, I don't know how in hell the judge is going to allow this. All I can see is her thinking about her case getting overturned. I mean, I think it would, I don't know. I don't know what is fair. She's made such a mess of it, letting these witnesses in and letting the defense get away with it. So I don't think there is any way to really make this fair. But I can't see her letting Hank Brennan, her approving this motion at all. Because the Commonwealth has the burden of proof. They go first. And then the defense goes. And I don't know. I mean, in some states, in Massachusetts, do you get a rebuttal? Only in closing argument sometimes, but not in your case. You don't get to retry your case. I don't know. I think Hank Brennan has to know this is a long shot. There's no way she's going to approve this.
The effect is pronounced. So what I want to do, Your Honor, is to look at what the reason Mr. Burgess has given, which leads me to be very concerned about a calculation and a strategy calculation here. Mr. Burgess states in his own words that the reason why that time is being changed is to, quote, align the trigger with Mr. Whiffin's analysis. And Mr. Whiffin's analysis is based upon the extraction data from Mr. O'Keefe's phone. And I believe it's undisputed that the extraction from Mr. O'Keefe's phone occurred years ago. And the data from that has been extant, it's been available years.
So what they're going to try to prove there, what they're doing is they're moving over. This sounds like they're making a time adjustment from the cell phone to the cell phone time, from the black box time back to the cell phone time, to show that once John O'Keefe is hit by, let's put it this way. Once there is an incident with her car, an event, her car has an event, it hits something that John O'Keefe never moves, so that the timing, right, is the same, and that he stops moving. I think that's what the Commonwealth's trying to prove by adjusting the time back to the cell phone time. So from the car time, there's a 30-second difference. Does everybody get that? From the black box time to the cell phone time? So the cell phone time or the car time, the black box time or the car time and the cell phone time, there's a 30-second difference. And I think that's what they're aiming to prove. And the defense knows how devastating this is. And they're hoping that no one will put that together. And so they're attempting to get it out. It's going to be pretty devastating doing this. And I also think that this is a clever way of a preemptive strike before the amount of work that ARCA has done sounds extensive, that they have just ambushed the Commonwealth with. So they want to get the first strike and cry ambush before the Commonwealth can. Again, the Commonwealth knows it's pointless. I mean, apparently they've done all sorts of testing, tons of discovery. They're Commonwealth experts on his vacation. They can't switch the experts, and he's already thought about switching the order of the experts. It won't make any sense to give the expert more time to do his own testing for the Commonwealth. They've successfully, it sounds like, ambushed the Commonwealth. This is very concerning. And believe it or not, cases are won. They know cases are won with this kind of trickery and this kind of underhanded stuff, these kind of disadvantages. I mean, look at Lally up against it all first trial. He's still got a hung jury. That's got to tell you something about Karen Read's guilt. It's not a success. You're still at 0.0. But the fact with Karen Read's innocence fraud campaign, the fact that the entire media was all singing her innocence, and he's still got the majority of that jury is going to vote guilty, sounds like. I don't know. The fact that, to hold, through days of deliberations, to hold on to their belief that she was guilty. Some people on that jury, let's call it that. Let's just be fair, because, we really don't know what happened on that jury. But we know that there were some people who felt very strongly that they couldn't convict, and some who obviously wanted to convict. So the fact that with all the forces, with crowds, with the crowd cheering free Karen Reed through the walls that came in through the walls of the courthouse, they still didn't get Karen Reed acquitted of even a small charge. And I'm not on board that they didn't understand how to work the jury slips. That's ridiculous. There's one for each charge. They were very easy to understand, and they were exactly what the defense wanted. So they argued for them and got exactly what they wanted. The simplest, a monkey could fill out those slips. You're telling me that the jury, very smart jury, Massachusetts, going to understand them? No.
Years ago. So to me, Your Honor, that basis can't be a proper basis at particularly this stage where we are approaching the end of the trial, just literally days before the testimony of Aperture. And we are in a very, very almost impossible, challenging situation. So, Your Honor, there are obviously, Your Honor knows the situation here. Our first request is that the May 8th report that we received on May 11th be not allowed, that it be not considered at all. As Your Honor knows, I don't like to use hyperbolic words.
He doesn't like to use hyperbolic words. He doesn't like to use hyperbolic words. I need a laugh track. He doesn't like to use hyperbolic words. If he doesn't like to use hyperbolic words, who does? He's such a dark character. I loathe him. John DiPietro put up on his X account that he loves Alessi. He thinks he's a great guy and wants to have a drink with him. That just, I was like, makes me wonder what's wrong with John DiPietro. The reporter sitting in the blue shirt on the edge of the, I believe that's it, the computer laptop, sort of a purplish blue shirt. I was like, wow, you're a bad judge of character. I mean, how did I say it wrong? Hyperbolic? Monica, did I do one of my famous mispronunciations? It's unreal. What's wrong with John DiPietro? You want to go to a ball game with this guy? I can understand saying, like, I want to have this guy come to my house so I can go to sleep, be talked into a sound sleep with his pretentious, nauseating drivel. I know. What's wrong with John? I know. But can you imagine saying that you like Alessi? You're a terrible judge of character. They're a terrible judge of character. He's a journalist covering this case from the Karen. He believes Karen Reed is guilty. He's the one who Turtle Boy played the. If you're watching the feed, Turtle Boy interrupted his feed and started harassing him in the middle of his live stream. I mean, if you did that to Turtle Boy, started harassing him, bombed his live stream, he'd hate it. Seek revenge. Never hear the end of it.
But the word has been used for us, against us, ambush, ambush, ambush. If there's ever an example of it.
The word ambush has been used against us. Well, if the phrase fits, Alessi, yeah, the phrase fits. Word fits perfectly. Ambush, ambush, ambush. Yeah, that's what it's been. What do you call erasing over 100 text messages, communicating on the Signal app? You did that all for the fun of it? That wasn't about hiding anything? How about telling the jury, the first jury, that your experts weren't getting paid? You never talked to each other and that you couldn't hand over discovery because of the federal investigation. That you were putting up witnesses you've never talked to before. About lying to the court, lying under your oath, disgracing your profession. How about that, Alessi? You're going to call an amendment, a small amendment, is now a Rule 14 violation? Give me a break.
An ambush, this is it. And so, Your Honor, our request is that Your Honor find a Rule 14 violation, that Your Honor have the remedy be that the violation remedy be that this is not allowed, and that the Commonwealth proceed with its the information of.
Caribou, we think so much alike. I'm always pulling up I feel like I'm always pulling up your comments. There's a couple of you that we really think alike. I pull up your comments sometimes because we're thinking the same thing. This guy volunteered for this job. He volunteered. He's like, oh, a cop killer who killed someone murdered a lovely man in the worst way possible. A guy taking care of 2 orphan children, killed him in the worst way possible, clipped him with her SUV, left him to die alone in a blizzard. I'm gonna represent that woman. Woman who started a witness harassment campaign. One of the most heinous. I mean, between Wendy Adelson and Karen Reed, I'll take Wendy Adelson any day of the week. We're talking about who's the better person. Wendy Adelson by a mile. And I don't think much of her either. I don't like murderers. I know I'm old-fashioned that way. This used to be the norm. It used to be the norm. Now everyone wants to jump on the let me help out a murderer train. Oh my law.
Aperture that has been extant before the May 8th date of the report. Thank you.
Right. Do you have another option if that's not something that we do, right? Because the Commonwealth moved to exclude ACA or have them go by their old report, right?
Right. And Your Honor, I'm going to answer your question, but with just a quick point that this is really much different than ARCA because 2 reasons. We are the defense, and ARCA is
Your Honor, we're talking about murderer Karen Reed, and these are her feelings. Her feelings are seriously hurt by this. You're trying to give her every advantage possible. In fact, you're only ever consider Karen Reed's feelings and how you can help her get an acquittal. Because you're a former defense attorney yourself who used to handle some really disgusting clients of your own. Remember that client you had, Judge Cannoni? The guy who snuck into a 6-year-old girl's bedroom and raped her and then strangled her with her own necklace. Remember that client you had? He wasn't so appealing. You know what it's like having a psychopathic client. Come on, help us out. You know what it's like. Oh my Lord. Enough of this. Anyway. But it would have been fair. What Hank Brennan was saying is, I would like the ARCA witnesses to testify. Just hand over the discovery. Just give us the same consideration we've given you every step of the way, Commonwealth. And every time he talked about it, Alessi would come up with some kind of little amendments, tiny, minute amendments they've made to their presentations and say, well, that's a discovery violation, this minute difference, and argue it till he was blue in the face. And then Hank Brennan said, look, we'll have him testify, just not to anything new that we can't rebut, that we don't have time to look at. That would have been fair. Not so with Judge Cannoni. Let it come in. Let it all come in. Just leave the Commonwealth totally flat-footed. That's why So, yeah. Can you imagine Alessi? Just, I don't mind. I really like to come in for free. And I like to advocate for a murderer in front of the victim's grieving family, especially Peggy O'Keefe, whose hand never really leaves the side of her eyes. She's constantly wiping her eyes, the tears from her eyes. The grief never ends. It's like just she sits in court like an open wound. If I can make those wounds a little bit deeper, richer, and really help out her son's killer, I'm going to do it. And I'm going to do it for free because it might help my career. Disgusting. I have such loathing for Alessi.
Rebuttal to the prosecution's case. That is much different than a prosecution changing its theory of the case at this time.
I understand that. I'm just asking if you
Right.
have
So-
another
so-
option.
It's not what I am saying that I am proffering. I think the only remedy here is exclusion and a Rule 14 violation.
And you're not waiving that.
I'm not waiving that.
No, I'm not asking you to.
Your Honor.
Okay, a continuance for how long?
I could have a better answer perhaps to that question tomorrow. I haven't, given what's been going on, I haven't even had a
Right.
chance to talk to ARPA. at
All right,
all.
so tomorrow morning, let me know that. All right,
In Your Honor,
Let me just say one other thing about the dynamic with this. There is one video. I have to find it. I have it on my Instagram, but there's got to be a better way to pull it up. If you have it on YouTube or X, let me know. Send it to me. But there's a video of the defense team all hanging out, and Alan Jackson is cooking what is been labeled as the meat blob. It looks like some, how do I say it? Concave meat. Is that right? Convex or concave? Maybe convex. I don't know. Like boob-like, let's say it that way. Boob-like meatloaf, like just with this red sauce dripping off of it. And there's Robert Alessi sitting there. They're talking about the Traveling Wilburys, that band, that all-star band of Tom Petty and Bob Dylan and George Harrison that was playing on the radio as they're cooking and having drinks. David Yannetti's having some kind of cocktail. Karen Reed's there and Robert Alessi's there, like the nerdy kid with the cool kids, just so ecstatic that he's in with the big time, that this civil lawyer can finally strut his stuff with the cool kids. I mean, his pants are so ridiculously tight, like the tightest pants I've ever seen on a human being. Does anybody else know that video?
I will do that, of course. And I will also say, without getting into an elaboration of it, we have to look at all the witnesses that we called. I'll give you an example. Mr. Whiffen, I had my whole cross-examination, not whole, but a significant part of my cross-examination of Mr. Whiffen based upon going through human volitional conduct off that phone that was after that 1162 trigger. And a lot of our defense in theory.
Yeah, she was totally ready to take down Jeff Lacasse, but that was only one person. Karen Reed harassed so many witnesses, went after Proctor, went after everyone who got her. I'm not saying there's a huge difference between they both turned my stomach, but I say Karen Reed is worse than Wendy Adelson. I would prefer to spend time with Wendy Adelson if that is my Sophie's choice, Wendy Adelson or Karen Reed. I think Karen Reed is much darker. And both are very psychopathic, selfish, etc. But I'll choose Karen Reed. You're right, Jeffrey Lacasse. But Jeffrey Lacasse is so delicious, isn't it? He figured it all out. He was He read that family so well, eventually, not originally, but so well.
Is based upon that's been in existence now for several months. And again, I go to the bottom line that the proffered reason in Mr. Burgess's report is to align with the data on Mr. O'Keefe's phone, and then that's been around for a long time. So that's my answer to your honor.
All right, thank you. Mr. Brennan.
Your Honor, this disclosure is not a Rule 14 violation. The Commonwealth, just like the defense, is entitled to continue to work on their case and study their case as time goes on. This issue, the relevance of this issue, has been clear throughout the case, including my opening statement. And the issue is that clocks are different. There is a clock in a Lexus that runs on a different time than that of an iPhone. If you recall, in my opening statement, I talked about the fact that there are variances between those clocks. So instead of a moment that coincides happening at the precise second, sometimes there's a variance of time between the two. So the Lexus clock could be at a variance with an iPhone, but the event still could happen at the same time, given the clocks have different times. The defense provided a report by a person by the name of Mr. DeSorga, a noted expert witness who they've listed as witnessing the potentially called. Mr. DeSorga wrote a report, and in the report, he suggested, based on his analysis, that Mr. O'Keefe's phone always ran late. That means if the texting data, the black box data from the car, has a event at 12:32:38, 12:31:38, and Mr. O'Keefe's last movements were 12:32:16, last user interaction 12:32:09, there is a variance between those times. We asked our expert to review their expert's report to see if he was accurate, that the variance means that these times would never align. And that's what he did. He studied the data, he studied the waves, he studied the Lexus black box relative to the time. Doesn't change anything, doesn't change the data whatsoever, just adds to the time. What he learned, from his opinion, is that Mr. DeSorga was wrong. He used information from different phones, not recognizing the items that these timelines came from, and that his time estimates are wrong. So then he looked at the time of the event of the ignition on and off, and he compared that to the Waze data. And when he did, he found that he could identify what the actual differential was. Instead of guessing that it was within the 30-second window, it was somewhere around 21 to 25 seconds. And that.
Okay, now I'm learning even more. It's a 21, 25 second window. See how, I mean, so we've gone from a 30-second window to a 21, 25 second window. Interesting. I'm learning. I listened to this like 2 or 3 times day before this show. So there's a differential. So Alessi takes the fall. Yeah, isn't it curious? Anytime there's some big heavy duty, I always say lifting, but heavy duty lying to do, they give it to Alessi. My view.
7 minutes before the collision, Mr. O'Keefe's phone was 21 to 29 seconds ahead, which means you subtract that time, which puts it in the same variance that we've been arguing from the beginning, that the collision occurred at the same moments when Mr. O'Keefe's last had user interaction, and that reconciles with the data. It does not change the text stream data or the black box information on the car whatsoever. It does not change ARCA's analysis whatsoever. We received this report on May 8th. I was surprised to receive it. I welcomed it. We turned it over on May 8th. There was no delay. It's been a week now. The defense has had this information. And so this is not an attempt to align anything. While it may reconcile or identify that variance more closely, it doesn't change any data whatsoever. And so this is not a Rule 14 violation. The effort was in response to disclosures that we believe were wrong by the defense expert, and it is clarified and it is favorable for us, and so we should be able to use it.
Did you intend to use it in your case in chief or only if this witness disorder? I don't remember reading that name, so I don't know how to pronounce it.
My case in chief, because we now have this available data.
This is like Karen Reed has to be one of the most animated defendants. Usually they sit there, Ghislaine Maxwell, Larry Ray, all dark personalities. Ghislaine Maxwell, Larry Ray, Keith Raniere. But there's not any of these huge leaps forward. And, if there was ever like a lean forward, it was Keith Raniere handing another Post-it note. Shout out to Tony Natale. I hope you're healing well. But, to hand over another Post-it note to Keith Raniere, the Nexium guru, would hand over these endless Post-it notes, but they would never make faces. They couldn't. No judge would tolerate this kind of just incessant talking in court, moving around. It's so rude. It's so deeply rude and narcissistic. That's who she is.
As I said, this wasn't ambush, isn't something that we sat on. It was in response. Fortunately, we received their expert report, which caused us to focus more closely. And now that we've identified that variance, rather than having an open variance of 30 seconds, we should not be precluded from favorable information that has been provoked by a report by the defense.
Okay. Yes.
I'll do it quickly.
Okay.
Attorney Brennan has provided a lot of information, and he has accurately provided information, but he's got the time completely wrong and the significance respectfully completely wrong. I'm going to hit his 4 categories quickly. He said he referenced Mr. DeSorbo, who is a defense witness. Two points about Mr. DeSorbo. First, Mr. DeSorbo provided his expert report within this reciprocal discovery deadline.
Okay.
And he provided that
Wait. The defense handed over a report within the discovery deadline? That's got to be a first for the defense. We got to have a little celebration there. Are they saying they have a defense witness who actually handed over discovery in time?
report months ago.
Okay.
So as I heard Attorney Brennan, he's saying the reason why we're getting something on May 8th is because Mr. Burgess supposedly is responding to that. That was months ago.
Okay.
The more apt point is, or an even more apt point is, Mr. DeSorbo was responding to the information of Aperture. It wasn't like Mr. DeSorbo was coming up. He was rebutting as defendants do. So, and it's Mr. DeSogra, D-I-S-O-G-R-A. Again, D-I-S-O-G-R-A. So that's an important point with regard to Mr. DeSogra. Now I want to go to Attorney Brennan's comment about clocks are different. I agree with Attorney Brennan on that. The shortcoming for Attorney Brennan's argument, however, is that the clocks are different concept has been in existence in this case for over 6 months. I can give you by memory Mr. Whiffin's report of December of 2024, where his report went into the different clocks and what their significance was. So that is almost 6 months ago, at least 5 months ago, the issue of different clocks has been in existence in this case. So therefore, the issue of different clocks dates back to then. But even more fatal for the Commonwealth's argument.
Wait. Are we talking about different clocks in terms of, was Ian Whiffen looking at the black box data clock? Does anyone know? Or is he just saying that it was a concept? Because he was looking at the different time on, say, an app and a phone and different phones and stuff, and the way things are time stamped. Something else that Innocence Fraud Watch talks about in her blog, that the pull behind me text sent by Jen McCabe, the timestamp we have for that is when it gets time stamped by, I hope I'm not getting this wrong. Hold on. I believe it's John O'Keefe's phone. Okay, 12:31:47 is the time Jen McCabe's pull behind me message was time stamped, not what she did. Okay.
Is that Mr. Burgess himself issued his report and talked about the difference in clocks. He already knew it. He already had it.
Did he testify to that last time? Did he testify?
Aperture was not part of the first.
All right, I thought Burgess was, no?
No, neither.
Okay.
No one from Aperture was.
Yeah, I
Your
knew
Honor.
Aperture was, and I thought he may have been something. The name just sounded.
Neither
familiar.
Burgess nor Welcher were
Okay.
part of the first trial, but they were retained. Aperture was retained, I believe, in October of 2024.
Okay.
And at best for the Commonwealth, Aperture had, and Mr. Burgess and Dr. Welcher had Mr. Whiffen's report that talked about the clock differences. So the clock differences cannot be, as the Commonwealth is proffering, some sort of new information that caused Aperture to provide a new report. This variance that Attorney Brennan talked about, it's called the clock drift. A more layperson's term is a variance of time. Mr. Burgess, in his original report months ago, has a whole section on clock drift. That's not a new concept for him. He's just changing the drift.
Okay. So what I'd like to do, because I want to address the other issue and I don't want to keep people here.
Excuse me, Your Honor, do you get my drift? I think the Commonwealth should drift downstream with their argument. How many drift analogies can you get? She's like, enough. I can't take it. Do you know, Mr. Alessi, you have what Roberta Glass's mother would call an unfortunate personality? So let's listen to Cannoni, what she's going to decide to do. I think she's going to go with the defense. There's no way, I cannot see her saying, okay, Commonwealth, after you're done your case, defense gets up, gives their case, and then you're allowed a special rebuttal. It would be fair with all that they've been put through, but fairness doesn't come into play here. I think Judge Cannoni sees unconventional, and she sees automatic overturning of her case. And it always seems to be about protecting face with Judge Cannoni. I mean, to really deal with the deep fraud that was done, the fraud upon the court done by the defense in this case, she would have to admit that it was all done under her nose. And when it was revealed to her, when it was exposed, all the stuff that she made happen by letting it happen, she shook, she made a big deal, and then she had a kind of a flip out and canceled court for the rest of the day. So I can't see her doing this. I don't think there is a chance in heck of this, of the Commonwealth getting this motion. But I will be pleasantly surprised if Judge Canoy's like, okay, since there's been such a heavy Rule 14 violation, sure, come in and rebut the defense, and then the defense can get a rebuttal. I don't know what. I mean, it'll just go tit for tat, sort of like a cross-examination. I don't know. What do you think? So curious. Let me just put up quickly before I go. Let me play this, and as I do, I'll put up a little poll in the chat for you guys.
Too long. Can you wrap it up, Mr. Alessi, or is that?
In 60 seconds.
Okay.
Thank you, Your Honor. Your Honor, the last point I wanted to make, and I think I heard Attorney Brennan correctly, is he said he was surprised that he got this report dated May 8th. That's what I heard. So if the Commonwealth is surprised that they got it, that should mean, to me, Your Honor, be an outstanding fetching reason to not allow it because they're surprised to get it. And I can lastly say this, Your Honor, there's nobody that's more surprised to getting this than the defendant when we got it on May 11th.
Okay, thank you. The other issue about calling your expert on rebuttal, Mr. Brennan, based on the late disclosure of the ACCA materials. What's your argument on that?
I won't iterate the entire passage. Your Honor has found discovery violations. Your Honor has found that I want to phrase this properly, efforts of the defense were improper. And inevitably, we've now received an extraordinary amount of discovery on the most important issue in this case, well beyond the discovery deadlines, without any excuse. And the court, understandably, has overruled the government's objection and has stated that it's going to allow the defense to proffer two expert witnesses in a very complicated field, in an issue that is the heart of this case. We're going to allow them to testify, despite the fact that we have not had adequate time to review, to prepare, and to address it. The Commonwealth has the burden of proof. The Commonwealth has an obligation to prove its case beyond a reasonable doubt. And this isn't simply late disclosure of some evidence. This is a massive amount of evidence of the most critical issue. And so we provided this information to Dr. Wesley. As you know, he was away. We did not get a report until maybe May 7th. We did not have a chance to look at it until May 9th. An extraordinary amount of work, effort, and expense has gone into preparing our case to the jury. He is still in the process of reviewing the materials. There are entirely new subject areas within this information, well beyond the simple 4 opinions that they gave at the beginning. There are studies, there are demonstrations, there are experiments. This requires not only review, but an analysis, testing, vetting, and then preparing testimony to address the claims made by the defense experts. Not to get into a battle of disparagement, but our expert has found extraordinary issues in his first reviews of the material. And some of those concerns lead him to need, in his opinion, to actually conduct his own tests to demonstrate the failures of these ARPA witnesses. That's going to take time. We've heard from the ARPA witnesses themselves. With the amount of data they received, they estimated they needed 5 weeks. And they were given 5 weeks despite all the discovery deadline violations. They were given 5 weeks. We did not get the report until May 7th. And so we believe we are entitled to have our expert review all the materials, do his testing, provide opinions. None of that is going to happen anytime soon because he still has not finished reviewing all the materials. There's many, many gigabytes. He is in a difficult schedule. He is away tomorrow, Saturday, we were going to try to begin to prep at the end of the weekend. There's no way he's going to be able to testify anytime soon and have all this validation and vetting and testing.
So what is it exactly you're proposing?
So what we would like to do is have him testify about what he has prepared, that he's had adequate time to prepare. If either of these ARCA witnesses testify and they introduce new opinions, new testing, new demonstrations, he should be able to continue reviewing the materials, actively engage his own testing now. So by the time the defense case is over, he will be prepared to come back and address the new issues, not the older issues or regurgitate his testimony, but to address any new issues that were provided in violation of discovery orders. And so that he can then address the jury on those specific new issues. I see no other way of this expert fairly being provided and presented to the jury. The unfair prejudice cannot be cured in any other way. We ask that he be able to continue his review, offer rebuttal opinions on.
When has she cared about unfair prejudice? So how are we doing on this poll? It just started. I'll give it a little bit more time. But people are saying that I'm wrong. I'm way wrong. So far, more people are saying yes. I'm shocked by the optimism.
Anything that is new and not to encroach on anything that's been previously provided.
Can Burgess testify after Welcher?
No, because Dr. Welcher relies on Shannon Burgess' information material. It will make no sense. I thought about it. It makes no sense to the jury, his presentation, unless Shannon Burgess has an opportunity to provide the background information.
Right. Mr. Alessi, I'll hear you on this.
Thank you, Your Honor. I think and I understand that it's very well understand the time of the day, so I'm going to do this hopefully efficiently. When we're talking about ARCA and the information of ARCA, it's very important analytically to put them in their two proper buckets. The first bucket is the information and opinions of ARCA that have been in existence since February of 2024.
Yeah, let's focus on the beyond. Let's focus on.
Okay, good, because my pithy conclusion is there should be no prejudice on that.
And I don't think the Commonwealth's even suggesting that. So
we're focusing just on the quote new information bucket. Your Honor, it's very important to understand that what ARCA is doing is in response to the testing of aperture. ARCA did not come up with new approaches. We, again, to state the obvious, are the defense. We get to rebut what the prosecution has put forward. And so what ARCA has done with the new information, new testing, is simply to rebut what Aperture has done. So I do not understand the length of time or the lift, if you will, that's being proffered for Aperture. Now, with regard to the time period, Your Honor has already determined what the appropriate approach is for the new information from ARCA. When Dr. Rentschler was on the stand, or Dr. What you said, when can you get me the information? And they said, I think it was May 6th or May 7th, whatever, and they met the deadline. They did it. We proceeded along with the trial with that information. We complied with that request to continually try to claim that there should be ongoing remedies of something that's already been decided. I do not understand.
So I did leave open. I did leave it open to address.
You did leave open the time, but Your Honor didn't leave open that you were going to continue to address this matter as if the defense is making perpetual violations. There was a determination made, and then the question was the remedy. So I'm just addressing the Commonwealth, positing that somehow there's continuing violations. My final 2 points. What Mr. Brennan is seeking is improper. What it's seeking is the most extraordinary situation, which is have Aperture come before the jury, testify to certain things, have ARCA have to come on, and then have Aperture come back and essentially have almost a rebuttal to a rebuttal as of right. I do not understand that process. I do not understand that proposal. It inverts the order of proof. It prejudices.
You know what inverts the order of proof? When you don't hand over discovery. In fact, there's still some discovery that the Commonwealth doesn't have because you ordered, I believe, this is a belief. I just don't believe everyone spontaneously deletes their messages. Call me crazy, but I do live on planet Earth and I was not born yesterday. So you're telling me that all the defense attorneys, and I believe Karen Reed was on this, had to be, just the way she's running her defense, had to be on this group chat before they moved over to Signal, where they auto-delete. That's the advantage of using the Signal encrypted app. Karen Reed's favorite way of communicating. They all deleted every single text messages between themselves and ARCA. Not to hide it from the Commonwealth, it's just they all had the habit of deleting all their text messages. And Daniel Wolf got caught in a lie. He's the ARCA accident reconstructionist whose wife joined the Free Karen Reed Facebook group right after he testified. Is that he said first that he switched carriers and he couldn't get the messages. But then he realized that didn't make sense because I was saying, like, look, I switched carriers and my messages, when I turn on the phone, they're still there. And then he was like, oh no, I deleted them. I just delete all my messages. So he told two stories, two lies on the stand. Then he switched to the Signal app, communicating on the Signal app. He's a practiced liar. He smiles when he lies, Daniel Wolf. Reminds me of Patrick Bateman, American Psycho, creepo guy. But you know what? You got yourself into this mess. If you had just done the right thing and not tried to pull a fast one and cheat to win, you wouldn't be in this position, Alessi. So where are we on our poll? We are 52% say yes. I'm so shocked by the optimism of my audience. Love it. Say 25% say no, but she will allow D a rebuttal.
Is the defendant, because it almost ipso facto gives a double rebuttal, surrebuttal to the defense. I believe, Your Honor, the final point is, if Your Honor is inclined to give Aperture more time, and I haven't even heard a deadline yet for Dr. Welcher. It's still open. What I would recommend, Your Honor, is that we follow the proper order of proof. We determine when Aperture can conclude its review of the ARCA work, and that there be a reflection that keeps the order, namely that the prosecution comes in with Aperture, Dr. Welcher, and Mr. Burgess. And then the defense, as part of its case in chief, puts on ARCA, and we make the determination as to what happens there. Otherwise, what we're happening is here, it's almost a self-serving matter where the Commonwealth is getting to put on certain witnesses here from our witnesses and then have an automatic rebuttal. And Your Honor, I just think that's improper and prejudicial. There's another, and importantly, it's a burden shifting to the defense.
All right, so I have a question for you, Mr. Alessi. Are you still thinking that if the defense puts on a defense, that will take roughly a week and a half for that to take place?
That is our best estimate still, Your Honor.
And not holding you to this, because obviously you have no burden. If ARCA is part of that defense, when in that week and a half time frame would that be?
We haven't made a final decision, Your Honor, but we're pretty close that it would be toward the end.
Okay. All right.
Right,
I
but-
needed all this information, so I appreciate it. All right. Thank you.
See, doesn't it sound like she's not going to do it? She's like, you have no burden. I know the state has the burden, but you know, I just think the way she's putting it, it's like, when are you going to do this? Oh, and so she's going to come back and tell the Commonwealth. Well, I mean, their whole case is going to be a couple days, I think, just like last time. Maybe 3-4 days at the max. Maybe longer with Alessi involved. Maybe 5 days. Now I'm thinking about Alessi. Maybe I'm wrong. He does long cross-examinations. But Tracy says, why doesn't she want to take responsibility for what she did? How does she plan on living with herself? She's never had any grief. She's a psychopath. She doesn't have feelings that way. She doesn't have any remorse. She's already said she didn't love John. Everything she does is an expression of how much she hates the O'Keefe family, including John O'Keefe. And wants to still enact revenge and re-victimize them. She doesn't have any remorse at all. She feels bad not a bit for anything that she does. She's already said she doesn't feel bad for the witnesses that she helped harass. Her and her lawyers. This is why I say I prefer Wendy Adelson. Not by a lot, but give me Wendy Adelson to hang out with rather than, that's my choice. So Sophie's choice. I'll take Wendy Adelson over Karen Reed. I don't know. I see it so clearly. Don't you see it so clearly who Karen Reed is? I mean, she's told us, if you open up your ears and listen, she's told us who she is. Everything she does is an expression. It's all about her. I mean, to go back into the house and say, I want to see the kids and never even talk to them. Just say, oh, this is a nightmare for me. Not, I'm so sorry I just killed your uncle, orphan child that I cared for 2 years, helped care for. Not very well, but okay. Say anything. It's more about hiding my crime now. It's more about covering up my crime and getting my stuff. She was there for 15 minutes. 15 minutes before she hightailed it out of there. So do you know what I'm talking about? So when she went back from the hospital, she got back with her parents. She's like, let's go to 34th. We got to get the murder weapon. We got to get the car and my whatever stuff I have. And hightailed it to her parents' home in Dighton. She was there 15 minutes. So I'm curious what they have on if they have even some kind of time stamp for, curious if they have that, the Ring app. Because I don't think that it was done then. I think she was covering up her crime much earlier and much more aware of the evidence she's leaving. I mean, especially if you think about, I don't bring up this garage door. I mean, the reason that Lally made such a big deal out of it, and I was too much of a dunce the first time around to pick up on exactly what he was getting at. It's like, spoon feed it to me, Lally. Spoon feed it to this time. I got it. Okay. Thank you, Innocence Road Watch, for putting it together. But is that it says so much about the cover-up. And Hank Brennan was really good in his opening statement. And Tony Natale, the great Tony Natale, is in the... Hold on, I'll get back to that. To Hank Brennan's opening statement. Tony Natale, you say no, she's not going to let it? I agree with you. I'm with you if that's what you were saying no to. Hank Brennan was really good in his opening statement saying that there's two parts to this crime. The crime and then the cover-up. And the cover-up started pretty much immediately with those phone calls. I'm on my way home. I don't know where you are. You're sleeping with someone else. Okay, so that's what I have for today. I think that's it. I think nothing will be done about this. I think the Commonwealth is going to be totally ambushed at trial. I think when Judge Cannoni said, I'll hear you out. That's all she said. I'll hear you out. She didn't say I'll help you out or I'll try. I think what we all heard is like, I'll help you out, but I don't think she's going to help the Commonwealth out at all. Her interest is entirely with Karen Reed and getting Karen Reed off, helping to get her off. It amuses me so much that the Free Karen Reed readers, she gave everything to Karen Reed the first trial, including keeping out Karen Reed's own statements. I don't know on what ground she kept those out of the first trial. Too prejudicial? But once you give up your right to remain silent, all that stuff, as you know, can be used against you in trial. She should have known, but it wasn't because Judge Cannoni protected her. What about Judge Cannoni not putting a gag order on her lawyers? She did 2 weeks before trial. The small things that have gone against the defense have been so minute compared to the massive frauds, basically frauds upon the court that Judge Cannoni has let happen in her courtroom. So I agree with the Free Karen readers. I don't like Judge Cannoni, but for totally opposite reasons. All right, that's what I have for today. Please support the channel. I'm going to be back tomorrow, still doing, during this Karen Retrial, I'm still doing 2 shows a day and 1 on the weekend. So pretty much 6 days a week. So 2 shows, 5 days a week and 1 or 2 on the weekends. Please support the channel. Links are in the description of this episode. You can buy me a coffee, become a Patreon member, get access to content you won't get anywhere else. Or shoot me a Venmo. Buy me a coffee, Patreon, Venmo, all great ways to support the channel. Also, hit the thumbs up on your way out. I'll see you tomorrow about 10 to 9 a.m. in the morning. We'll be back first full day with Karen Cam, hopefully. I'll see you all then. Thanks so much for listening. And leave me a comment too. I really do get a lot. I read every single one of your comments. I get a lot out of them. Really appreciate them. Please leave me a comment. Share this episode. Subscribe to the channel. And I'll see you tomorrow, a little before 9 a.m. Have a great night, everyone. Thanks for listening.
I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment. I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system I clown. Innocence fraud campaign to save my skin. my second victim. Carry, carry, gin, gin. Like John, you were my mom. My innocence fraud campaign is my biggest hit. Yeah. I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing, I pushed the pedal down, hit him hard. Now the legal system I clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim.